We have other caller, Raju from Bangalore. Hi, Raju.
Yeah, madam, sorry, my line got dropped. I don't know whether I was disconnected or I was. Well, two things I missed out on that. So one is, of course, I wanted to thank you, but more importantly, actually, this is for my son. He's already got his. I told you, right? He's got interview for his business visa. Just a quick question from him. We have been waiting all night here in Bangalore because it's too early now. Uh, if he comes on a business visa, and is it legally possible for him to parallelly apply for a student visa while he's there in the US without coming back to the country?
So yes, it's possible, but they're always going to look at it suspiciously in the sense that you have to make sure that he had no intent of being a student before he entered into the country, because he's basically entering saying that this is what I want to do. So they shouldn't be
Right.
If there's an intent issue, and if they find out that he had this intent of moving to an F1 even before, they'll say, then you should have just come on an F1 and not given the wrong reason for entering. So they might find that
Right.
entry to be illegal. So in order to avoid that issue,
Right.
then it's better to wait for maybe 60 days or 90 days before you file for a change of
Because of
status
this
from a B2 to an
COVID, we
F1.
lost about 6 months of all this education planning and all here in India because the embassies were not there. So his employer has applied for a business visa as part of the job and he wants to continue his education. So I was just thinking, ma'am, do you have a representative or office here in South India or at least in Bangalore with whom we can meet up and maybe seek some advice? Would that be possible?
We have an office in Hyderabad, not in Bangalore. You could email me and I can send you the details.
Oh, sure. I will do that, ma'am. I just wanted to thank you earlier. It got disconnected, so thank you for your information.
You're welcome.
Thank you, Raju, for calling back. We have other caller, Krishna from Chicago. Hi, Krishna.
Hi. Hi, good evening, madam. Thank you for the opportunity. I have one quick question. My wife visa, actually H4 visa, is valid up to March 25th, ma'am. If she wants to plan I don't know whether is there any grace period to stay one more 10 days to go India, or before 25th she should leave the country?
So why don't you file an extension?
Because one thing is, like, if I file a extension now, she wants to needs to go in the month of May, madam. In these 2 months, the decision won't come, right? That is,
yes, it won't come, but anyway, you can file anyway. It doesn't matter that it won't come. Just keep her in status. But there is a 10-day grace period for the I-94, but sometimes that is included in the I-94 itself. So you have to make sure that you're not adding an additional 10 days to what has already been added, right? So look at the H4 I-797 at the bottom. The top will not have the 10 days grace, but the bottom I-94 attached to the I-797 will usually have a 10 days grace. But if you have the I-94, which is online, which is from the port of entry, then they will not usually have that 10-day grace. So you can add 10 days to it. But make sure you're not confused as to when that 10 days ends.
Okay. Otherwise, you said that other way, like, we can apply extension here and she can, without decision comes, if she travels to India, is the visa getting the need to go for stamping again in the consulate in the Hyderabad?
Yes, because the thing is, if she doesn't have a visa, how is she going to come back? And the visa would have expired, right? So the filing here becomes null and void. When she leaves, it becomes null and void because she has to be in the country for it. She has to at least come back into the country. So how will she come back without a visa? So, and anyway, for a H4, you don't need to have a 797 filed initially. So you can just come back, go to the consulate directly, get a visa and come back in.
Oh, okay. So that is the best way. Before applying only, she needs to travel. That is the best way, right, madam?
Right. So instead of saying that additional time, she should leave earlier if she plans to leave anyway. Or she needs to file for an extension.
Oh, okay.
Thank you, Krishna. So again, back to our question. So what are the list of documents to be submitted for RFE response for maintenance of status for F1 cap gap?
Oh, cap. So basically, the F1, specifically cap gap, just to rate for those audience, people who don't know, is when you file a change of status from F1 to H1, it might be that because the new H1 as per the cap doesn't start until October 1st, right? You're filing 6 months in advance. So in the interim, it's possible that your F1 status might expire. Either your OPT is expiring, or maybe your school is getting over, whatever it might be. In order to accommodate such people, the USCIS has come up with a cap gap rule. And as per the cap gap rule, whatever your status was as of the date of filing, as long as you were in status as of the date of filing, USCIS automatically extends that status until October 1st. So that's what the H1B cap gap rule is. And in order to make use of that H1B cap gap rule, the only thing you need to do is submit a copy of your H1 petition which you filed, or a copy of the receipt to your DSO. So that's the requirement for the H1B cap gap. So suppose you're on OPT, and even if your OPT expires during that time, you can still continue to work because your OPT has been artificially extended as per the H1B cap gap. If you did not have OPT at the time of filing, then if you get it later, and if it expires, then you cannot work, obviously. So whatever your status was as of the date of filing, that will be your status. Okay. So sometimes they send RFEs. I don't know when they send RFEs really for a cap situation. They might send an RFE saying prove that you're in status, and if you're working and you continue to work, then they might say that prove that you contacted the DSO or something like that. But usually cap RFEs are rare. You don't usually get an RFE saying prove that you've been approved for a cap because there's an automatic approval. Okay. As long as you inform the DSO. And that's been included in the service.
So also right to control RFEs, are we still getting those? Yeah, I think we touch based on this a little bit.
So right to control RFEs are not happening anymore, except if there was a mistake. So again, we touched base on this. There was a litigation, as I was saying, and the Trump administration was trying to use that right to control law to pretty much deny 50% of the RFEs was really right to control, and the denials were based on right to control. Not so much specialty occupation, but more right to control. So that was taken away from USCIS, and that's why now we have less RFEs and less denials. And also they were denying, they were approving cases for 1 day, 2 days, 1 month, based on this right to control law. So the right to control law basically said that you have to prove, if the person is not working at your office, but is working at a client site, the petitioner is obligated to prove that they have the right to control the day-to-day activities of the employee, and that they are the actual employers. And just being on the payroll is not enough to show that they are employers. They have to show the right to supervise on a day-to-day basis. Also, the right to control rule said that you have to show that that right to control existed for whatever period you're asking the H1 for. If it's 3 years, then 3 years. So that led to a flood of RFEs asking for right to control documentation. So they wanted it they wanted it not just in the form of a statement from the employer or petitioner saying that yes, we have the day-to-day control of the activities. They wanted it from the client, from the horse's mouth, from the client. So we had to get detailed in-client letters saying that the person has the employer has the right to control and not us. The employer has the right to hire and fire, not us. The employer has control of the general duties of the beneficiary. The employer has the right to reassign the beneficiary to a different project. We don't have that right. So all these, this language had to be listed in the end client letter. And sometimes the clients would refuse to give all that language because they wouldn't understand the importance of it, or they just said that we don't know who has that right. We don't have it, but we don't know if the employer has it or not. How do we know? So they would just refuse to give it because they would be afraid of, saying something that was incorrect, maybe not having enough information. So when they didn't get such a letter from the end client, then we had to produce other documentation to show that in fact the employer had the right to control. And that was in the form of an employment contract where those terms and conditions were enumerated, were specifically there saying that, oh, we are going to be controlling your duties, everything had to be spelled out in the employment contract. Right. And that we have the right to give you the bonus, we have the right to control your salary, etc., etc. All those terms and conditions had to be written in the employment contract. And also, we had to actually show documents like the review documents, so the documents going back and forth between the employer and the employee saying that they have reviewed the work. Based on the review, they have done salary increases, or so reviews going back and forth every 2 weeks. So that documentation will be submitted, and then to show that this is happening for a period of 3 years, they would ask for purchase orders or letters from the client saying that the project will last for 3 years. If any of these things were not there, they were denying the cases. And it's very difficult to get this kind of documentation that I'm just talking about. So a lot of cases were getting denied. Right. Then we had, there was litigation. ITServe filed a case and they won. And the judge basically said that it's ridiculous. Why do you need to, what is this artificial definition you're giving of employer and employee? Where did you get this definition from? The common law definition is if you are hiring, firing, and if you're paying, then you are the employer. So nothing else is needed. So everything went out of the window, and now we are not seeing, neither are we seeing short, and they also said you cannot give short 1 day, 2 day H1 approvals. You have to give the H1B approval for the entire 3 years. If you're not giving the H1 approval for 3 years, you have to give reasoning behind why you're not giving it. So, so that is now we are seeing 3-year approvals, and we are not seeing RFEs for right to control anymore. But the USCIS tried to reintroduce this whole concept recently through the DOL, as I was talking about. The DOL issued a memorandum saying that if you do not have the right to control, basically then the end client also has to file the LCA and H1. So this would end the consulting company business completely, because no end client will be willing to file a H1. If they are willing to, then they'll just hire them directly. Exactly. Why will they go through the pain of, you doing the H1 and all that? The whole consulting company process works this way. So if that is not there, then it will not work. So they tried to do that, but luckily the Trump administration did not have enough time to publish that regulation. They didn't do it on time. They didn't do it by the 20th. So the regulation was automatically rescinded by the Biden administration because they said that if it is not published, then it has to be rescinded. And the DOL memo that talked about this also had to be withdrawn, the press release, because there was no regulation. So there's no basis for the DOL thing as well. So that's what happened with right to control. So they keep trying to introduce it, and keeps going away, and then they try new ways of introducing it. But I'm hoping now with the Biden administration coming in, I'm hoping that they won't go after consulting companies in this way.
Sure. And the last question, what is a golden immigration message to our viewers?
I guess what we need to do is we need to document. So we need to document our cases properly.
Sure.
We need to make sure that USCIS does not have an excuse to deny, right? So I think providing upfront complete packages with all the documentary evidence is important. That's one thing. Second, we've learned from this present administration that the only way to get the rights that are ours, and the only way to make sure that we get our immigration benefits is to litigate. Don't be afraid to litigate in federal court, because otherwise USCIS will not listen to us. So we've learned that lesson, and there's been so much immigration-based related litigation, and 90% of the litigation has been in favor of against USCIS.
Sure.
So all the decisions have come out against USCIS. So don't be afraid to litigate. For example, H4 EADs, H1B wrongfully denied cases, litigate. And what is happening is that USCIS is withdrawing, is not even waiting for the decision from the judge, but is approving cases. Okay. Because they know they're already in the wrong.